Surprise! We're here. You never know with us whether we're going to be here this week or not. But we are here. Greg Siskind. I'm joined by Marshal Garbus. Uh, Marshall and I were just chatting about the what time does this game start?
In 30 minutes.
Okay, we're doing a short live stream tonight because we have a basketball game that is a priority game. I don't care who wins that game. We were just saying that I root for the Tennessee teams. Marshall roots for the New York teams. The Tennessee teams, by this time of any of their pro seasons, are usually thinking about the drafts and thinking about what what went wrong. Usually, it's usually a discussion. I was showing Marshall something I was proud of today. You can see in my little caption that if you were tuned into the live stream earlier today that I did with the Impact Lawyers, I was still in my bike jersey because I was trying to get this ride done. But as you can see, I crossed 60,000 miles today. This is after 15 years of riding using this app. I've been riding for more than that, but the bike apps for iPhones really only were around for that long. Marshall, we lost you. All right, he'll be back in a second. Anyway, I won't make you suffer through that, but where's Marshall? Marshall was immediately ditched as I was bragging on myself. Okay, so we're gonna keep it short. But there are a number of things to talk about this week. The big thing, and of course, big discussion that just about every immigration practice in the country is talking to their clients about is adjustment of status. So last week, Elisa and I, well, when the policy was announced that day, Elisa Taub and I did a live stream kind of talking about what we knew at that point. We were both predicting litigation, and I'm still not saying it's not going to happen, and I may be involved in it myself when it does happen. But at this point, we don't actually have any denials, right, Marshall? Nobody's heard anybody actually being denied anywhere in the country on the policy. Is that
right?
So? Where are we right now with respect to this policy? Tell us like what we know.
Well, the most recent update or indication we got from the government was kind of through the back channels in the New York Times article that came out on, what was that, on last Friday?
Yeah.
Wasn't that there was an anonymous source from DHS that was kind of explaining how they're kind of backtracking the policy, and that they really was just emphasizing that it's a discretionary process, which it always has been, and that this is really being overblown.
Right. Well, all right. So we have some. This is typical where something very illegal is announced and very controversial, and then they, and you see a lot of the diehards in the administration, the political people on social media, saying one story, and then behind the scenes, reassurances that are going either to media or members of Congress or to the actual people at the agencies themselves, saying this is not what it appears. So we seem to have a little of that going on. We do know right after the policy was announced that we were getting reports from different immigration practices of very similar questions that were being asked, these extra questions. You can mention those in a second. But then in the last day, we've heard from our own sources inside the agency saying that the officers are being told to hold off and just go back to the policy and go back to processing cases the way they were before. Is that an accurate description?
It is today until if they're trying to work on more guidance from the agency, we'll see. But it seems like they're scaling back.
Yeah. So, and Chuck Cook and I, when we were on our live stream at 2 hours ago, we were talking about it. And one thing that we have seen some cases getting approved. So it's not, and these were cases that were approved after the policy went into effect. But We're also hearing that examiners saying that they are not denying the cases and they're doing the interviews, but they're holding off on making decisions, waiting on a supervisor's approval. So I'm not, that's one thing. And Chuck was saying that he's been seeing that in his area. Um, so it seems like examiners are not really sure what to do at this point, whether they can approve or can't approve, whether they're using the new policy, the old policy, and what to do with these cases. So um, I think really all and people keep asking, I'm not sure how you're advising, but they're asking, should I switch to consular processing or should I stay with the adjustment or should I file adjustment if I haven't done yet? And my inclination is if you wanted if adjustment was what you desired to do, you should go ahead and pursue that and either if you have to you'll make the arguments that you need to regarding that you deserve to be able to adjust, or the courts will deal with it, but in any case, if you are currently filing for adjustment to switch to consular processing, you have to file an I-824. That's going to be like 4 to 6 months based on current processing times. If there's some big rush of people to file those applications, then we could see those processing times get a lot longer. We just saw a dramatic drop in the number of consulates that are going to apparently do immigration processing in Africa today. Those applicants are now going to have to process in other countries. So all consulates around the world are probably going to get a lot busier. Consular processing is going to be a mess. And unless there's a really, really compelling reason to switch to that, I wouldn't be making changes. But I don't know if you have any of your own thoughts on that.
No, it sounds right. I mean, it's very back depending on where you are. If you have underlying status. There's a lot of different factors that go into the risk assessment. But I think generally,
right. Plus, you have these 75 country bans, on immigrant processing as well, where consulates are, even if you are want to go through that process, they're just not moving those cases. And there was, by the way, a nice win this. I think it was actually today. I think it was in Boston on a 75 country ban case against the State Department where a judge wasn't having it. Our own case is still pending on that, and we'll hopefully we'll have some news soon on that case. Like a lot of the cases right now in federal court, it's dragging on, and people are like, "Why are these cases taking so long?" And I think I talked about it with Elisa, but maybe I didn't. But there has been some really interesting reporting about, and I feel like I'm an AI optimist, I guess you'd call me, and one that likes a lot of the things that about it. But AI is a destructive force in the federal courts, not because of anything wrong that AI is doing, but because so many people are now filing cases that they wouldn't have filed previously. It's not a question of like using, I'm going to save some money and use AI instead of a lawyer. These are cases that they would have never gone to a lawyer with, but because it's basically a DIY, they're filing themselves, and they are flooding every federal court in the country with these pro se, which means filed by the individual, pro se lawsuits using AI to file them. Now, a lot of those cases really are garbage, and but the courts still have to deal with all of those. So it really makes the cases on, for the cases that we're filing, a lot longer to process in these courts because these judges are just dealing with such massive caseloads that they never have dealt with before in their whole career. So I don't know how that's all going to shake out, but if people are wondering why the courts are taking so long on every one of these cases that are out there, it may not be politics. It may not be anything about the particular cases or what the DOJ is doing. It may be AI. Okay. So, Marshall, anything else on adjustment that we can tell people right now, or just hang tight and see what we see emerge in the next couple of days and weeks.
Yeah, I think we're taking it week to week, and we'll hear more inevitably.
Yeah. All right. What's next on the list?
Let's see, something positive. DHS extends TPS for Lebanon. That was on May 29th, automatically extended through November 27th, 2026.
Yeah.
So people that already have the EAD cards.
Is this like the first Trump
Yes.
TPS extension or designation or anything positive on TPS in this whole administration?
Yeah.
Wow. Well, all right. Take your good news where you can. We're going to talk a little bit more about TPS and when we talk about Supreme Court, but so that's some good news. What else you got?
Let's see. I don't know if you covered this last week. We had the EB2 category for Indian nationals is used up for the rest of fiscal year 2026.
Yeah. So tell us why that matters. What does this mean for the average applicant?
So for applicants, generally there's a certain allotment of visa green cards for individuals that breaks down amongst family or employment-based categories, and then it further breaks down based on individuals based on their country of birth. So there are also, you might be familiar with certain backlogs for Chinese and Indian nationals, countries that have high volume of visa applicants. So this year, due to the high volume of green card applications, we've run out of the EB2 visa category for Indian nationals before the fiscal year has ended.
Okay. All right. So so that's the that's the EB2 stuff. By the way, this State Department scaling back the consular posts in Africa that I mentioned a minute ago. Do we know when that's happening, or has it already happened?
I think we don't know when it's happening. There's nothing official out yet. These have been pretty much like leaks from behind the scenes in meetings, but I think in the near future, in June, July, we can expect something to happen. Nothing officially announced yet, but seeing the general trend of consular processing in Africa, it seems this is in line with everything they've been doing. Immigrant visa processing is, if you look at a map, is pretty much blacked out over most of the continent. And yeah. Okay.
I saw on the list you put something about the gold card. What's new with the scam?
So the SAVE service, which is it's a way that USCIS administers the registration of immigration status. I'm not terribly familiar with the SAVE program or function, but
it's basically how a lot of government agencies can verify people's status. So it sort of like gives official status to, I guess, to people who get it. But there has, according to I was just looking at I just pulled this up about a month ago. Apparently only one person had been granted this status. So I guess that it's a real program if one person got it. I'm telling people don't buyer beware on this, because I think that this is all going to be taken down by the courts at some point. Right now, I'm not sure anybody is going to litigate and say they were displaced because one person got a green card. It's probably not going to be very compelling. If it becomes if more people start to get it, it's going to get litigated. It's probably going to lose because the Immigration Act doesn't have anything remotely resembling this program that's authorized. And it's possible that a person could lose their money and lose their green card. I think people should be really careful about it. So, yeah. All right. So we have gold cards. I saw on your list. I think we've gone through have we hit the big topics that you wanted to cover? Because I wanted to talk about the 2 Supreme Court cases after we went through your list.
Yeah, that's what I got on my end.
Okay. So the Supreme Court we're in June. The Supreme Court has had all the arguments for the year that they're going to hear. And they had more immigration cases than usual this year, but partially because this administration is so active on the immigration issue and there's so much litigation. It's not a surprise, but there are two big ones. There might be more immigration cases that are like on smaller issues or less high profile issues, but there's two really big ones that we're waiting on. And they're going to probably be the really big one is birthright citizenship. I'll get to that in a second. But the other big one involves TPS. Birthright citizenship will be the last decision of the year. I can promise you that that's what's going to happen. And that will usually be the last week of June, first week of July. The optics are going to be horrible if it's a bad decision to do that right before the 4th of July. I actually think that it's going to be a unanimous decision. And it's because the language of the Constitution is pretty clear. Because anybody who's born in the United States is a citizen. That's like it's not vague.
Subject to the jurisdiction thereof.
Subject to the jurisdiction thereof, but there's basically the only thing that's ever been in dispute on that is whether children of diplomats who are subject to the jurisdiction of a different country by diplomatic relationships and treaties that make that determination. But there's also evidence, and my favorite evidence that in this whole thing is from around the time, they oftentimes will look like, what did the people that wrote this amendment, what did they have in mind? Now, obviously, this was during the period when slaves were freed, and this was sort of a key part of whether they were going to be able to be full participants in the democracy after they were freed. If they had to become citizens, they weren't considered citizens while they were slaves. But there would have been a number of members of Congress who that would not have been citizens if you interpreted this the way the administration is interpreting it. That you had to have both. I mean, in the administration, it's not just whether you have legal parents, and anybody had that concept back then between illegal and illegal, but just whether your parents were citizens themselves and had permanent status. But that was there would have been a number of members of Congress who had been kicked out of Congress had the rules had the amendment been interpreted the way the Trump administration is interpreting it. And that's an absurd thing to think about, that people would have been voting for an amendment, including some of the people that voted for this amendment in Congress would have been kicked out of Congress if you had interpreted it the way the administration is saying it. I find that to be a pretty good evidence that they did not read it the way the administration was. Plus, we had a Supreme Court case in the 1890s, and we've had, basically 125 years where it's not even, it's been unquestioned. That's an issue, but there's like a lot of other issues that come up in that case. Does the court treat undocumented parents and temporary visa holder parents differently? Do they rely on the constitutional text, as we were talking about, original public meaning, common law history, statutory codification under Section 1401A of the U.S. Code? Does the court say a president can redefine citizenship by executive order, even if Congress might have some room to legislate at the margin? So it's not necessarily, even if you think there is some room to legislate on the issue, can the president do this by executive order? That's different than saying that Congress has to do it. Is the courts, is the court going to get into things like how hospitals state vital records offices, passport agencies, Social Security Administration determine a newborn citizenship, and how that, is that going to create this whole new bureaucracy to make that determination? Um, or does the court rule? The court could also, the court could rule broadly on the merits, or they can find some narrower procedural off ramp and say that, the and make some ruling on venue, or ruling on standing or something. They've done that before as well, when they just decide at the end that they can't, that they don't want to give the president a real loss. So that's there's a lot of directions the court could go, but I still remain very confident, and I'm sure that someone will point this out to me that I was completely wrong, but I still remain very confident that that decision is going to go the way that I think is the right way, which is that birthright citizenship will remain. That help us if it doesn't. That's the one, so that's the case. By the way, that case is called Trump v. Barbara. I'm not sure uh, who the Barbara is, but that I think there were 4 cases that were consolidated. And that was one of them. Now, the other one we talked about, Lebanon before, but this is the TPS case. And there's 2 different TPS cases. One is called Mullen v. Doe, is for the Syrian TPS, and the other is Trump v. Ayat, I think, involves Haiti TPS. The Haiti TPS is really probably the much, they're getting a lot more attention because we're talking about 350,000 people that are affected by that. TPS for Syria, I'm not sure what the numbers are, but it's nowhere close. Syria had its TPS, the designation, I think, ended in November 2025. The administration said Syria no longer met the statutory criteria. And this, I'm not sure if that was before or after the war ended in Syria. But for Haiti, I think the dates for Haiti, I don't have the date in front of me, but the arguments were they consolidated the cases. They heard the arguments on April 29th, so it's still relatively recent that the arguments happened. So DHS is saying TPS is temporary, discretionary, and tied to changing country conditions. The plaintiffs are saying the administration didn't adequately consult with the other agencies. They misused national interest language. They ignored country conditions. And then they, in some arguments, acted using pretextual or discriminatory reasons, which seems pretty easy argument to make based on things that the president has said over and over again. So this case is, what to watch for. I would say, does the court hold that TPS decisions are essentially unreviewable, or does it distinguish between review of a TPS decision and review of whether DHS followed their own procedures? That's sort of a different question of saying that they could say it is subject to review, but DHS did enough that the court can't revisit it. The court could say the Administrative Procedures Act applies to TPS termination cases and they have to go through a process, or the court could say immigration deference to the administration swallows most review. They could address this pretext or discriminatory motive, or they could avoid by deciding the case on just statutory reviewability. They could offer an opinion that only affects Syria and Haiti, or they could do a broader decision, blessing the broader TPS rollback strategy. So there's a lot of different directions the court could go on TPS. I think sort of the one thing that connects both, there are a couple things that connect both the cases. One is, basically essentially how much can the administration use executive power to make sweeping immigration changes without Congress. And I think that a lot of the future of the protection of humanitarian protection programs is kind of tied up in this TPS decision. And I don't think if the TPS decision goes with the White House, then I think we just start seeing them. It sort of like reminds me of this voting rights case that the Supreme Court made, where it pretty much opens the floodgates to lots more actions in terms of, and probably the TPS case would be used by a lot of courts as far as what courts can do to review executive action and when the Administrative Procedures Act applies and doesn't. So could have broader implications than just the TPS case itself, and we'll keep an eye on that. Now, Marshall, I've got 4 minutes of your time left before tip off. Anything else that you want to add this week?
We got one question.
By the way, if people want to know about the lawsuits, if you go on to I think it was broadcast on my X channel earlier. You should watch that, and you'll see the updates on the cases. And I see 2 questions as well, which we'll get to. You want to go to the questions?
I'll do this one. Will the new memo, I'm assuming the AOS memo, affect current LPRs in the U.S.? Will you sue for relief?
This is from Robbie, our friend.
Okay.
Hey, Robbie. All right. So regarding the, do I think you can argue that being from an IV banned country is an argument you can use in favor of adjustment? I do, because there really is there are no rules here on, you just have to basically show that you're worthy of it, your case is worthy of exercising discretion. And I think that that's a favorable factor. It could be an unfavorable factor if they think that somehow the 75 country ban is, a good idea. But if it's super clear that you're not a public charge, and that's the whole basis for the 75 country ban, and if you left the country, that's a pretty good reason not to consular process. And that's basically one of the things you have to show, is that you have a good reason to adjust versus consular process. I would definitely make the argument. But I would come with other things too, about the wonderful things that your client is doing. So, Robbie, Marshall, what do you think?
Yeah, it's crazy. It's just being statutorily eligible on itself is a positive discretionary factor. Absence of any negative, factors is a positive factor. It's like I don't understand how they can just insert these negative discretionary factors, in there. So it's hard to say.
I think Robbie, just go in prepared to make the argument, but I bet you won't have to make it. All right. Second question was from Orlando Love One. Will the new memo affect current green card holders in the U.S. and will we sue for relief? So the answer is yes, it does affect those people when the memo actually starts to take effect, which, like we were talking about earlier, as of now, it doesn't seem to be being applied. But it would affect people that are already here. It's not just going forward and affecting new people. Will we sue for relief? If it looks like they're denying cases based on the new memo, that is something that we will certainly, we're certainly having discussions on that. I won't make any promises, but I would take a bet that there will be litigation and probably a number of people filing suit in different places over this memo if they actually start to try and apply it. All right, now Marshall, it is 7:30, and this is when we're signing off early tonight because it is not for NCAA baseball, which I love watching, not for the Stanley Cup, which I guess they get a night off from that. Go Hurricanes! But I will root for the Knicks tonight to be a supporter of Marshall, even though I really don't like either one of these teams. And it's a matter of being a Grizzlies fan and hating the Spurs more. So I will say go Knicks.
All right.
All right. Good night, everybody.
Good night. Bye.